All right, so this is going to be MPEP 700, and this will just be part one of it. So I'll go through about half the slides, and then I'll cut off the video so it's not too long, and also won't go over any reporting inhibitions I have. So the MPEP 700, kind of starting out, what we got. So it kind of goes through the rejection of the claims, the procedure of an examination, the replies and swearing back, so specifically those affidavits. So it kind of has combined 2100, which is the patentability chapter, and 700 concepts. I'll try to identify where 2100 is being used, but kind of just thought we'd combine that because a lot of the aspects of rejection are helpful when you have the actual definitions of what things are being rejected under. All right, so rejection versus objection. So rejection is going to be a lot of times statutory. It can be non-statutory, but it's almost always statutory. It is the way that you test it is you request the examiner for reconsideration. And then if that doesn't work, then you go to an appeal. And so when we're saying tested, we're just saying kind of like protesting whatever that rejection is. And it's based on unpatentable materials. That's be 101, 102, 103, and 112. So anything defined under there as being unpatentable. And the objection may or may not be statutory. So rejection is statutory, objection may or may not be statutory. The way that you test that is you request the examiner for reconsideration and you petition the commissioner. So objection, petition, rejection, appeal. Kind of easy one that way. Objections will be on the cases of improper formality, typically. And then you have your date of invention. So for only pre-AIA, the way that you base it off of is for the date of invention, 102A, 102E, 102F, and 102G is all based on that. The time the application was filed is 102A1, 102A2. So that is now the standard, right? So that took place March 16th, 2013. And so that was the AIA law that was put into effect. And so anything, everything is under the first to file rule here. So now comparing prior art dates for pre-AIA. So first you're going to determine the reference date for the prior art. So you're going to do for 102A and 102B, that's going to be the publication date. 102E, you use the filing date, and this is only that 102E is only US patents and WIPO. 102G, you're going to use the invention date, and that is used for interference, right? So if you're going up against someone else's patent in interference, then they get to use their invention date as well in pre-AIA live. So determining the reference date for the claims within the patent that you're trying to apply for. 102A, 102E, 102G all are based on the invention date. All of those, your invention date is what defines pretty much everything that it's based off of. And then 102B is based on the filing date. So your filing date gets compared to the reference, to the prior art publication date. So we'll cover more of that later, but this is just kind of a helpful chart to remember all the nuances of what goes off of publication date, what goes off of invention date, and then whichever one is earlier wins. So now when it comes to swearing back, and this only works for pre-AIA 102 and E, 102E. So 102A, 102E is rule 1.131. So it's an affidavit under 1.131. It's used for swearing back to the invention date, and it cannot be used to overcome statutory limitations. So 102B, as we'll talk about here in a minute, is when something has been published a year before the invention date. Or I'm sorry, a year before the filing date. So if it's been published more than a year before that, then it cannot be overcome with this affidavit. It can be overcome in other ways, but it cannot be overcome with this affidavit specifically. So then if the art claims the invention, like it's not patentably distinct, then there's three ways to overcome. So first off is going to be the alleged claim is entitled to actually an earlier date than the reference. So again, that's like swearing back, claiming perfecting priority, something like that. The examiner is wrong that the prior art does not teach each and every element and limitation of the invention. And then adding a limitation which distinguishes from the prior art. So all of these things can be done if it is identical and you can't swear back. So then the next kind of aspect in the way that prior art is defined is public use and offer for sale. So using pre-AAA rules, it's limited to the US and pre-AAA, but it's anywhere in the world for post-AIA, and that's secret, non-secret, anywhere. If it exists, then it can be used as prior art. It can be done in secret. The date of invention, they can be established in NAFTA countries, and WTO countries is 12/8/93 and 11/96, and they'll tell you in the cases if it's a WTO country or if it is a NAFTA country, which is helpful. So basically, if there are any pre-AA questions and you can kind of figure out exactly which country it's in, where it was invented, then that's kind of a helpful tip. So for 102A, it must be by another. For 102B, it has to be more than a year before filing by the inventor or another. And so when it's saying another, that can be any inventive entity which differs by one inventor. So if you have one common inventor, good for you, but you have to have all the common inventors for it to be automatically taken out. But again, that affidavit, the 1.131, that can be used to remove a lot of those prior art exceptions. The offer for sale does not have to take place, so there could just be a billet for offer for sale. There doesn't have to be an exchange of product, but it has to be of the actual product and not the rights, right? So if someone is selling an assignment of an invention, then that doesn't count as a public use or offer for sale. But if they have a contract for 50,000 widgets, that would count as an offer for sale, whether or not that ever actually took place. So then for publications or patents for pre-AAA, we have 102A, which is published by another before the invention date. 102B is when it's published but more than 1 year before the filing date by the inventor or another. And then 102E is US patents, US published applications, and PCT applications, only the filing date before the invention once published. So 102E has got a lot of nuances to it, but basically the 102E date takes place once it's published. That's the first part of it. And the filing date, it has to be, as far as PCT applications, there's a lot of nuances to it, but for US patent and US published applications, the filing date has to be before the invention date. In that case, so PCT applications are based on the international application date or their earliest US effective filing date. So an IA date after 11/29/2000 must designate the US and publish in English to have a 102E date. And prior to that, it did not have a 102E date if it didn't have any US priority. So then overcoming 102A and 102E using that 1.131, there has to be an actual reduction to practice, showing an actual reduction to practice, or conception and diligence from the critical day. So that critical day can be the effective date of the disclosure to the actual reduction of practice or filing date of application. So then the prior art patent rejection under 102A and 102E, which claims the invention, it cannot be overcome. And so an interference should be declared. So if it is a rejection, which identically claims it, then you can't just file an affidavit saying, well, we did actually reduce it to practice, because if it actually claims it, then that means that there would be two of the same patent out there. And so in that case, an interference should be declared. So then if the inventors are the same, only the proof of identity is needed to be shown to remove. So if they are exactly the same, proof of identity needs to be shown to remove the 102A rejection. So when it comes to provisional rejections, 102E, remember, it acts retroactively, so it doesn't take effect until it is issued, but it can be used in a provisional rejection if it's commonly owned or invented. So that can be overcome by abandoning one application. But if there's no common inventor or assignee, then you issue the one having the earliest filing date, and then it's used as prior art under 102E. So kind of to go into this a little bit further. So provisional rejections, that occurs if maybe there is two applications that are claiming the same thing. And so you can make a provisional or, patentably indistinct. And so you can make a provisional rejection where the filing date of one preempts the other, and it's saying, hey, just so you know, this issue is coming up. We see that it's commonly owned. You need to fix this in some way. And so for some cases that can be overcome with a terminal disclaimer or by canceling those claims which are in issue and that sort of thing. But it can also be overcome by abandoning one of those applications. And you'll see more about that in restriction practice and in MPEP 2100. So then the interference, that can be proper if the filing dates are within 6 months or 3 months for a simple matter. And just a reminder, interference does not occur post AIA. So post AIA, it's all derivation, no more interference. So then further for pre-AIA, and this is covered more in depth in 2137 and 2138. So for 102D, there's foreign filing bars, and these ones cannot be sworn back. So 102B and 102D cannot simply have an affidavit filed to overcome. So the rules that are what must be met in order for a foreign filing bar is a foreign application has to be filed more than 12 months before U.S. filing. A foreign patent must be issued, so it doesn't have to be published, but the rights have to be enforceable, and a same invention, same inventor, an assignee. So one of those ones, it has to be, all of those have to be the same. So then there's 102F, where the applicant did not invent. 102G, it's used as a basis of interference, so where the prior invention was created in the US, WTO, NAFTA. It couldn't have been abandoned, suppressed, or concealed. It's the basis for interference. And one it looks like I missed in here is 102C. And so 102C is if the applicant has abandoned the invention. And so when you might remember in MPEP 600, we talked about abandoning, express abandonment and that sort of thing. With express abandonment, or maybe we'll talk about it later in this one. With express abandonment, that one is going to be the abandoning of an application, not the invention. However, under pre-AAA laws, 102C can be used as a rejection that the applicant abandoned their invention in the cases where an applicant, they were talking very badly about the invention, how it would never work. It's a lot of times based on public comments. I've seen very few example questions of this, but basically you kind of know it when you see it. If the inventor for years has said that this wouldn't work, and then once they see market success of someone else, then all of a sudden they're on board with it. Kind of the basis of that one. So now what to AIA? This is the first inventor to file system. These rules are based on the filing date only. So it doesn't matter when you reduced it to practice. It doesn't matter when you invented it. It's only based on the filing date. So in this one, 102A1 and 102A2 are what define the prior art. 102B1 and 102B2 define the exceptions to the prior art. 102C defines common ownership. 102D defines filing date. And so then going more in depth, 102A under AIA rules. So for 102A1, it's based off of public use, offer for sale, issued or published patents, and that can be anywhere, and or publication. And so all of this, remember, it's anywhere in the world, but it's all based on publication dates, not on filing dates, but of the reference. Now 102A2 uses the filing date of the reference. So the US patent, the US published application, or the WTO, their effective filing date is compared to the application filing date. So versus 102A1, their publication date is compared to the application filing date. For 102A2, the filing date is compared to the filing date of the application. So now 102B, remember that is the exceptions. So, and it's covered more in depth in MPEP 2120. So for 102B1, it correlates with 102A1. And so that is based on a 1-year grace period. So if the disclosure was made by the inventor or another obtained the matter directly from the inventor within 1 year of filing. So that's 102B1A is the subsection there. And then if the inventor disclosed the invention prior to the prior art within 1 year of filing, right? So they disclosed it in January, filed the next January, but there was an intervening prior art in March or something, then the inventor can establish, hey, no, I actually did disclose it within a year of filing, and before this application, but sometimes that can't be overcome. So then 102B2 overcomes 102A2. And so remember 102A2, that is the filing date one. So when the filing date of a reference overcomes the filing date of the application. But there's another 1 year grace period for this. And so that is very similar when the disclosure is made by the inventor or obtained the matter directly from the inventor within 1 year filing. The inventor disclosed the invention prior to the third party filing within 1 year of filing. The subject matter not later than the filing date of the invention were owned by the same person or subject to the same obligation. So they'll kind of cover that a little bit more, but basically it's based off of the joint research ownership. So the joint research application, so the JRA. And so that's when subject matter was under some obligation to assign, or it came up out of a result of the joint research venture. And so the affidavit 1.130, which we'll talk about here in a moment, is filed to assert the exception to 102A under 102B. So now we'll go into what that looks like, asserting the exception. So starting with part A of this affidavit, this is what you would file if the disclosure was obtained from the inventor or the joint inventor or derived in some way. And that has to be accompanied by evidence of the disclosure derivation or the reasoning for the additional inventors, right? Because the only time this rejection would be made is if there was one or more inventors that was different from the application. So you kind of have to have a reasoning for why these inventors were not included in the application. So then part B is when the disclosure was predated by the disclosure from the inventor. So if it was publicly disclosed by the inventor or joint inventor before the rejection. But again, if this falls outside of that 1 year grace period for filing, then you're out of luck. You can't really make those same claims saying that, well, I disclosed it before, because then your own prior art can be used against you. And then it can also be you also use this one if you're publicly disclosed before the filing date of whatever the prior art being used under 102A2. And then you would identify disclosure mode and then provide the copy if it was a printed publication. There's no need to show that the disclosure is enabling. That's a big one. And then who files this 1.130? It's going to be the applicant. And so remember, applicant can mean a lot of different things. It can mean the assignee, a person of sufficient interest, or the inventor. But in this case, the affidavit would most likely have to be signed by the inventor, right? They're saying, I was the one who disclosed it, but then the actual affidavit is filed by the assignee or person of interest, whoever. But when is this not available is the really important thing here. If that disclosure, filing date, or publication date is beyond the grace period, if the prior art patent claims the same invention. So that's a big one. So if it's a patent and it claims the same invention, then there's a whole other set of rules. You can't just overcome it with an affidavit, because then you would have two patents out there claiming the same thing and be really subject to unfair patent term extension. So if the affidavit claims inventor derived the claim invention from the applicant, then in that case, that would go to derivation proceedings. So in that case, maybe they're not commonly owned, there's no common inventor, then you can make the claim for derivation in some cases if you have proof of derivation. So now when it comes to CFR 1.132, this can be used in pre and post AIA. So you use it with secondary considerations. And so secondary considerations are used when overcoming 103. And so that's going to be, proof of marketability, proof of success in the market, that sort of thing. And this one you would also use for utility or enablement requirements. You can use 1.132 to submit facts by an oath or declaration during prosecution, right? So this is something where you can say, hey, I'm certifying that this is a correct statement. I'm making this claim and I'm certifying that it is a correct statement with this affidavit. So just kind of giving a specific law to it. So now the joint research agreement that we talked about a moment ago, that would be an exception under 102B2C. not 102BA. So how to invoke or disqualify the disclosure is important. So the disclosure of the subject matter within the prior art was made by or part of the JRA, and the agreement was in effect before the effective filing date, and the claimed invention is within scope. So all of these have to be met in order to make the joint research agreement claim here. And so remember, this is not available if the application has already been, if it's a rejection under 102A1, only if it's a rejection under 102A2. So kind of going here, so if the publication was prior to the effective filing date, then it doesn't work here. It's only if the filing date, if they are close enough together that the filing date was before the filing date of the application, but it hasn't been issued. So now going further into 102C, so when the subject matter disclosed was a result of the JRA and was effect prior to the effective filing date. So there's lots of questions out there that can try to trick you, but basically that joint research agreement only has to be effective before the filing date of the application. It doesn't matter if it was in effect or not before that the patent that's being used as prior art. It only matters for this invention. So the invention has to be a result of activities within the scope of it. So if it's something that kind of was an offshoot or was not within, a very generous view of the scope, then it does not get the exception here. And then a lot of times you have to amend the application to have the same invention of the JRA if they are not already the same. So now 102D, we'd already kind of talked about what that means. So it's talking about the effective filing dates and what that means. And so it only applies to the US patents, published applications, and the PTO. And so effective filing date is really just a pretty easy definition. It's either the prior filing or the priority date to which it's entitled to. So then we go into transition statements. So transition statements, that is going to be needed when the new 102, so AIA laws, that's going to be filed when any part of the invention is filed post 3/16/2013. So if it's something that does not include matter, like if it was a continuation with no new matter added, then in that case, it still is under post or pre-AIA. But if it's a continuation in part and it has any matter which was filed post 3/16/2013, then in that case, the entire application needs to be examined under post-AIA laws and not pre-AIA laws. But on the flip side, 102G, which is the basis for interference, that one also still applies if any claims are present from pre-3/16/2013. So that is when a transition state would be needed. The RCE and national stage entry, neither of them trigger the need for a statement, right? Because you're just continuing the application, you're not adding anything to it. So now kind of going from there, we're going to talk about obviousness. So this is the next step of what rejections can be. And so the first 102, the section that we talked about a moment ago, that's all based on anticipation. If something is not identical or you can't say that it's completely anticipated under one reference, then it would be an obviousness rejection. And so obviousness, there's a lot of details to them. 21, 41, 42, 43, 44, and MPEP. All going to be super helpful to read and to really understand what obviousness, how those rationales are made, right? Because it's all based off of rationales for combining references to overcome an invention. So if something lacks an inventive step over XXX in view of XXX, where both of those references are prior art defined by 102. So it's all just based off of those same definitions of 102A1 and 102A2. Both of those prior art definitions still hold with 103. There's no difference in what is counted as prior art from there. There's no limit to the references which can be combined. So you can just keep saying in view of, in view of, in view of, as long as there's some motivation to combine them. And there's an example in the MPEP of a patent which was denied with 13 references, and the court upheld the rejection. So some examples of rationales of obviousness include predictable results by combinations, substitutions, known techniques, a known technique to improve similar devices. So, even though the device here is similar, this is a known technique and this device is not unique enough or, It's just not distinct enough to be its own thing. If the combination was obvious to try with a reasonable expectation of success. So if I'm switching out peanut butter for almond butter, that's, a pretty obvious switch, which would have probably some success in a sandwich. If there's known work with a variation or market forces. So if it's something like, this would be an effective treatment for cancer, it might be like, well, that's kind of obvious that this is a treatment for cancer, and that's something that's obviously needed by market forces. And so this would have been an obvious transition in that case. If there's some teaching, suggestion, or motivation, and so that the TSM, that can be inherent or implicit in prior art. So if there's questions that are talking about inherent properties, a lot of times those are saying, hey, this is an inherent property known to those of prior skill in the art. It doesn't need to be said if the question specifically says that it is inherent. So now, overcoming an obviousness rejection, that's going to be by, so prima facie is the name of the case that is a lot of times made for obviousness rejections, right? On the face of it, it's clear is what that, I believe, means. So you would establish arguments or submit facts, make the argument that a person of ordinary skill would not make the combination. The resulting combination is not the claimed invention, right? Even though you are making this combination, this is not what we were going for. You can amend to add a limitation, and that must be accompanied by remarks explaining how the rejections and objections are overcome. When adding the limitations, they have to be supported by the disclosure and not previously claimed. A supplemental oath or declaration is needed here. If the claims are canceled and new claims are added, the numbering starts from the last claim. So that's just more a formality. So if 1 through 5 are canceled, the new claims will start at 6, that sort of thing. So this will be the last one that we'll talk about for this section. So there's going to be 2 aspects to this statute. There is the rejections if it's not the real inventor, and that is done under 101. And so formally, that would have been 102F under pre-AIA, but now under AIA, rejections or not the real inventor is under 101. There are 4 categories of patentable material. So that's going to be article of manufacture, apparatus, method, composition of matter. Now, those which are not patent eligible, and probably see more of this as we go, scientific principles and mathematical discoveries, atomic weapons, devices for illegal purposes, doing a business, so any sort of abstract idea, anything that's naturally occurring that hasn't been reduced or purified in any regard, a purely mental process, and software, this is just kind of more a note than anything, is unpatentable unless it's coupled with a computer or machine. So that one's a little bit of a tricky one to identify if you don't have a lot of experience in the field, but just kind of remembering if it's not a software used within a machine, then it's basically just computer code without any reason. All right, so I'll go ahead and stop it here and then go to part 2. Thank you.